Hello students, this video session that we have today is on legal reasoning. Legal reasoning is one of the segments of your test in which people give you passages which are a fair size, about 3 or 4 paragraphs each, maybe between 350 to 450 words, let's say. And these paragraphs contain legal situations either in the form of principles of law that are discussed or in the form of situations where these principles could be applied. And then they would expect you to answer questions wherein you establish that you can identify the principles of law that are talked about, or you're able to connect them to the situations that they are giving to you. So this would mean that you need a little background. Now, we do know what it is that the CLAT themselves say. Let's just consider what they are talking about. Now, when they talk about the legal reasoning segment, this is what they say. They say in this section you will be expected to read passages of about 450 words each. The passages may relate to fact situations or scenarios involving legal matters, public policy questions, or moral philosophical inquiries. You will not require any prior knowledge of law. You will benefit from a general awareness of contemporary legal and moral issues to better apply general principles or propositions to the given fact scenarios. Now, what do they mean here? So, they've told you about the size of the passages. It could range, when they say around 450 words, please take it that it could be plus or minus 100. The passages may relate to fact situations, that means, or scenarios, which means they actually give you a case or an actual situation. And why do I say case? Because it says involving legal matters. So the situation is one where people involved are in some sense either affected or are making claims or are defending themselves, things like that. It could also relate to public policy questions because public policy is typically something that gives rise to legal entitlement, gives rise to legal responsibilities, and it could be moral philosophical inquiries, which is a very fancy phrase for what we would normally call fairness or ethics or proper behavior. Now it says you will not require any prior knowledge of the law. Now that makes it sound really interesting because you're saying, hey, so I don't need to have studied the law. No, you don't need to have studied the law. However, they add to that by saying you will benefit from a general awareness of contemporary legal and moral issues to better apply the general principles or propositions to given fact scenarios. And so they're saying you don't have to have studied the law, but if you recognize certain principles or you're aware of certain principles, that would help. In other words, some awareness of principles actually is going to help. So, what are we going to do to help you do this? So, you realize apart from just the legal reasoning part of our training program, we actually have bits where we talk to you about four major areas in law. We talk to you and give you material on contracts, on criminal law, on constitutional law, and on torts. Because these are the four most used areas of law. Now, in these, when we discuss these areas, we will discuss principles, we will discuss samples of situations in which those principles can apply. The idea being that you can then recognize when they give them to you in passages, you will be able to quickly recognize the common sense principle that is presented and you'll be able to associate it with a situation that it can be associated with. So, what we would request you to do is not just to try legal reasoning exercises, but also to try the content and the input and the exercises in those four areas that we've given you. Because when you add them up, they will, in some sense, boost your capacity to handle legal reasoning. Because even though these people say you will not require any prior knowledge of law, it certainly is going to help you to have some awareness. Fine. Now, what about the passages themselves? Each passage would be followed by a series of questions that will require you to identify and infer the rules and principles set out in the passage, which means, is there a principle I can recognize in what they're saying here? Or can I understand a principle from what they're saying here? And they would ask you to apply such rules and principles to various fact situations, which is in the question choices or in the passage itself, is there a situation to which this principle applies? And can I recognize that? Can I recognize the circumstances of that application? And understand how changes to the rules or principles may alter their application to various fact situations. So they have mentioned certain rules or principles in the passage, And then in the choices, they're going to tell me in the questions, they're going to tell me if this is altered in X manner, then where would it apply? So I need, again, you realize what we're talking about here is, yes, you may not need any prior knowledge of law, but some awareness is going to help. But more than that, you need to apply common sense and a sense of fairness, what we call a sense of ethics, because all of law is typically based on common sense and a sense of ethics. And therefore, if I can apply that, if I can apply my general sense of what is right and wrong and what is fair and unfair, I'd be able to tackle these principles. But to help me, it would also have some benefit to have a general awareness of these principles, which is what it is that we are also going to try and give you. So, what do I need to do in addition? Well, the fact is, some of these situations that they give you, some of these principles that they give you, apply to contemporary legal and moral issues, which means if you've been reading, well, when we say moral issues here, we mean ethical issues. If you've been reading the newspapers, if you've been reading articles and magazines on the net, then you probably are going to be exposed to certain discussions that are happening, which give you some awareness of these legal and moral or legal and ethical issues. So, a wide reading habit also helps over here. So, you need to build up your general awareness of legal principles, etc., from the books we've given you. You need to build your general awareness of things happening today in terms of, let's say, legal issues and ethical issues from the reading that you do on the outside, your papers, newspapers, magazines, internet, etc. And you need to put all this together into a general understanding of how things work in the matter of disputes which are legal. Fine? And that will actually help you handle the legal reasoning section. So now that we've given you that, we hope you will prepare on those lines. But also to give you a little head start, we are looking at a little exercise in this particular video where we're going to take you through certain passages, three of them, and questions related to those passages so that you can identify what it is that we're talking about here. Where are the principles here? What are the situations we have to apply them to? What kind of reading should I do to actually ensure that I grasp these things? We'll help you with that because as we read through these things, we'll actually look at them in some detail. Okay, so now let's get down to handling that part of it. Let's look at the directions to these questions. Each set of questions in this section is based on the reasoning and arguments or facts and principles set out in the preceding passage. So that means the passage is followed by questions, and therefore each set of questions is based on reasoning and argument, which means the two sides, the for and against a particular case, or facts and principles set out in the preceding passage. Some of these principles may not be true in the real or legal sense, which means they would sound fair, though they might not actually be law laid down. That doesn't matter. But many of the principles will be true in the real or legal sense, but some of them may merely be things to test your sense of your common sense of fairness, right? So some of these principles may not be true in the real or legal sense, yet you must conclusively assume that they are true for the purpose of this section, which means if they tell you X is true, then you proceed on the basis of X is true, right? Even though you might recognize no, X is true only under certain conditions. If they don't provide that, then and they say X is true and that's it, then you go with X is true. Please answer each question on the basis of what is stated or implied in the corresponding passage, right? Do not rely on any principle of law other than the one supplied to you, and do not assume any facts other than those supplied to you, which means you need to use those. You need to recognize those. And don't go beyond what you've been given by bringing in additional general awareness and so on. Your general awareness will help you grasp what you're talking about. Your additional knowledge will help you grasp what they're talking about, but you don't use knowledge beyond what it is that the passage itself gives you to answer questions. So don't use any principle of law or facts other than those supplied to you when answering the questions. In some instances, more than one option may be the answer to the question. So I could have two choices that seem to answer the question. But in such a case, please choose the option that most accurately and comprehensively answers the question, which means one addresses the question in some vague fashion or in some slightly incomplete fashion, whereas one gets into giving me a clear picture of why it is the answer to the question. So you choose the option that's most accurate and comprehensive in answering the question. All right, so these are how the directions would run. And now we can get down to dealing with a passage and some questions, and passages and some questions. We will take some pains over the passage. We'll read it in some detail so that you understand exactly how you should be reading it when you have passages like that to deal with. All right. So let's move on. So let's look now at the first passage that we have. Now you'll find that the passage has the question on the right, and every slide will be like that. There will be questions on the right. But I would urge you not to look at the question until you've finished reading the passage. The reason for this is I have some very clear reasons. When you look at the question before you read the passage, your eyes are drawn to certain terms that seem significant, certain statements that seem significant, certain pieces of information that you think are important. And then the tendency is to try and find those things in the passage to be able to answer the question. But the fact is, when people make questions, they might not use exactly the same words that the passage has. They are pointing to the ideas that the passage has, they are pointing to the opinions that the passage has, they're pointing to the principles that the passage may have and you may need to infer. So please remember to read the passage completely and carefully, understand it totally before you look at the questions. That's really important. So here we are not looking at that question. We are going to read the passage and then we're going to come down to the question. In reading the passage, there are certain important bits that we might want to go over, talk about, think about, etc. Now, UCB Limited was an industrial bakery producing naan bread. The process involved in baking naan bread means is simple present tense, right? So the process involved in baking naan bread means that the dough occasionally catches fire and emerges from the oven alight, which means this is not a process that is going to happen any one time. This is standard about that process. When that process takes place, the dough sometimes catches fire and the naan emerges from the oven alight. Now, in India, we know naans, so we have an idea of what they're talking about because you realize that when you have a naan that is finished, there are going to be some parts of that, small little bits like dots or maybe sometimes even larger than that, coin-sized areas, which are actually charred a little bit. How? Because in the tandoor, the dough actually catches fire and then it gets put out. Now that's over here when you say the dough occasionally catches fire and emerges from the oven alight. But the important thing to remember here is this part, which is the process involved, right? So one sec, this has gone to the next slide. We just need to go back to the previous one. So what we're saying is that the process involved, right, is the process involved means that the dough occasionally catches fire. So what we want here is we want to underline a few things. So let's see. So the process involved means, which means this is standard process. Okay. In 2003, UCB entered into a contract with Spooner Limited, whereby Spooner supplied equipment to transport the cooked naan bread from the oven. So if they supplied equipment to transport, it means that this was an automated process where people were not drawing the naan out of the oven, but the equipment was bringing it out. Later that year, the conveyor belt in the equipment caught fire. So we understand something else. We realize that the equipment contains a conveyor belt on which the naan obviously comes out from the oven. Later that year, the conveyor belt in that equipment caught fire. Luckily, the damage was limited and Spooner repaired the equipment with replacement belting from Forbo UK Limited. So what was damaged in the equipment was obviously the conveyor belt, and the conveyor belt was replaced by Spooner with belting purchased Forbo. UCB were concerned, now this is important, UCB were concerned that the fire had been started by the burning naan bread. That means they were worried about, was it our process that caused the fire? Was it the process whereby the dough occasionally catches fire and emerges from the oven alight? Was it that process that caused the fire on the conveyor belt? So they were concerned about that. In an email exchange, UCB asked Spooner and Forbo to confirm that the correct material had been used in the replacement belting. Why are we talking about correct material here? Because since the process means that mildly burning naan does sometimes come out, the correct material would be one that doesn't catch fire from the naan. We understand that. So in an email exchange, so concerned about that, they asked them, did you use the correct material? Now, if they ask them, did you use the correct material? Correct for what? So correct obviously for this process. Fine. suitable for the intended use. So there you have that again. So what was it correct for the process? Was it suitable for the intended use? Forbo wrote to Spooner and UCB in 2004, stating that it was very unlikely that a naan bread would cause the conveyor to belt to catch fire, which means they were saying, now when you say very unlikely, now just keep note of that. When you say very unlikely, what is likely, what is unlikely? Obviously, you're talking about likeliness or likelihood or the absence of it, keeping in mind certain conditions. So it is not likely in those conditions, is what you're talking about. So when the people say very unlikely, it means they know what it is that they're dealing with, what process, what circumstance, and in those circumstances, they believe it's very unlikely that an naan bread would cause the conveyor belt to catch fire. So Forbo wrote to Spooner and UCB in response to UCB's concern, isn't it? In response to UCB's concern here in this part. So in response to UCB's concern, they said it's very unlikely that a naan bread would cause the conveyor belt to catch fire. In 2006, the conveyor belt caught fire again. This time the fire spread and destroyed part of the factory and the machinery. UCB raised a court action against Spooner and Forbo claiming that, and they made two claims, that they had failed to take reasonable care. They had failed to take reasonable care, right? So failed in taking reasonable care when advising UCB that the conveyor belt was suitable for use in the naan bread ovens. So that means if they were going to tell them it was suitable, they should have been careful about assessing the situation before they said that. And they had a duty to take reasonable care to advise UCB that the belting material is unsuitable for use. Which means if they thought it was unsuitable, if Forbo and Spooner thought it was unsuitable, they should have actually informed them, and they should have taken reasonable care to inform them that it was unsuitable. So that means they are claiming two things. If you did not take care to establish that it was reasonable for our use, and you had a duty to tell us if it was not going to be, no, you have to take reasonable care to establish that the conveyor belt was suitable for our use, and you have a duty to take reasonable care to establish, to tell us when it is not suitable for our use. So in other words, UCB's claim is basically about the fact that these chaps were careless in dealing with them. Forbo and Spooner, in countering the claim, stated that the expression that it was very unlikely that naan from the ovens would melt the belting was made without. So we are talking about in countering their claim. Their counter was that they didn't know about they had no special knowledge of UCB's processes. So they are saying that when we said very unlikely, we said that without knowing what your process is. Now, how do you say that? How do you say likely or very unlikely if you have no idea what the process is? But they are saying this. They are saying it's very unlikely doesn't mean that we knew what your process is. They highlighted that the letter from Forbo did not state that the belting was suitable for the use. What did the letter state? The letter state was very unlikely that it would cause fire, isn't it? Or it would catch fire, which is a way of saying don't worry too much about it. We don't think it's going to happen. So did they have to state that the belting was suitable? No, they actually implied that it was. So they are now finding, they're hiding behind two statements. They're saying very unlikely doesn't mean that we knew what the process is, and very unlikely does not amount to saying that the belt is suitable. Very unlikely to catch fire does not amount to saying, so they are saying they did not state. So they are hiding behind the fact that they did not actually state that. But the point is that they implied it. They did give the impression that it was not likely to catch fire. Okay. In allowing UCB's arguments in their case against Spooner and Forbo, Lord Hodge, the judge, highlighted three common characteristics that should be considered when determining whether it is just, fair, and reasonable to impose a duty of care in such cases. In other words, if you really want to know whether people have a duty of care and whether it is fair and just and reasonable to expect them to have the duty of care, then ask yourself three questions about the statements that they make. What is the context in which those statements are made? What is the foreseeability of reliance on those statements? And whether the statements contain any qualifications. So the judge says if you want to determine, for somebody who's made statements to you, if you want to determine whether they had actually used or not used care in making that statement, you should consider the context in which the statement is made. Okay. You should also consider the foreseeability of reliance. That means, will somebody actually rely on the statement? and you should consider whether the statement contains any qualifications. Now, in particular, he noted that while the maker of a casual statement, that means he also made a very particular point, that while the maker of a casual statement in a social context may not owe a duty of care, which means if you're saying something casually, socially, there you may not need to be terribly careful. But a person making the same statement in a business context may, which means if you were to make such statements in a business context, even if they're casual, then you really have to be careful about what you're saying. Okay. He eventually determined that Spooner and Fobo were primarily responsible for the second fire since 1. Spooner had sought to create the impression that the conveyor belt was fit for the intended purpose after the first serious fire. And 2. Fobo, though aware of UCB's concerns after the first fire, had responded with a letter that was calculated to give reassurance, which means on going through what it is that these guys have said, very unlikely he has, and very unlikely that it was the bread that caused the conveyor belt to catch fire, and that too in response to a letter from UCB asking whether the right material was used. Very clearly, they had sought to give the impression, so he says they had sought to create the impression that the conveyor belt was actually fit, right? Was fit for intended use. And FOBO, though aware of UCB's concerns, they were aware of the concerns, they actually responded with a letter that was calculated to give reassurance. So, which means the judge holds them responsible. He says, you guys allowed them to believe that the belt you gave them was actually okay. Now, let's just understand this. The claim from UCB is that these fellows were negligent, they didn't take reasonable care, they should have taken reasonable care to establish that the belt was suitable for use when they told us that, and they should have taken reasonable care to tell us if the belting material was not suitable for use. The judge, however, though he may have dealt with that, that is not discussed over here. What is discussed here, he says that those guys made statements without bothering to check whether they were making the right statements. They created an impression, they gave reassurance, even though they knew that they should not be doing that, even though they were not sure themselves whether the material was fit. So that is what this passage says. All right. Now, keep in mind the entire discussion we've had, because if you can recall parts of this discussion as we go along, the, the handling of the questions becomes very much easier. Okay. Now let's take up the first question that we have here. So the question asks, which of the following in the context of the passage would be a reasonable assumption for UCB when Spooner repaired the equipment after the first fire, which means the repair was completed, and an assumption would mean that UCB would have believed that in repairing it, there is something that these people have done or taken into account. So a reasonable assumption is, an assumption basically is what you think a person must have kept in mind when they did something, which means UCB would have assumed that Spooner kept in mind something when repairing the equipment. And what would be a reasonable assumption then? So let's just look at this. Now let's look at the situation here. We know what the standard process is, right? Sorry, we need to go back one sec. So we know what the standard process is, right? We are told here that the standard process is about naan bread sometimes comes out of the oven. Okay, the process involved means, which means that's a standard, that the bread sometimes comes out with a little fire on it in some spaces, right? Now we know that the equipment had a problem and the conveyor belt caught fire. Now, if Spooner had supplied equipment and the conveyor belt caught fire, what would you normally expect them to do when they repair the equipment? They would want to know what the reasons for the fire were. And having known what the reasons for the fire were, they would then repair the equipment with replacement belting. So obviously, UCB would have assumed that in repairing the equipment, these guys would actually have paid some attention to what was the reason for the fire in the first place. And then they would have established that, okay, we know what the reasons for the fire are, and now we will replace the belting, which means they would have understood what the process is and believed that this belting is probably quite okay, right? So they would would it be an assumption that they would do so, that they would repair at no cost? But cost is not discussed here in those first two paragraphs. Would the assumption be that they would do so with compensation for earlier damage? Again, cost or compensation is not being discussed. Would they do so with attention paid to the possible causes of the fire? Which means, would they look at the process and ask themselves, is there something in this process that could have caused the fire? Yes, UCB would have assumed that these guys would have studied that, and having studied that, had decided on the replacement belting that they chose. Would it be that they would acknowledge the responsibility for fire? That's not discussed here because we've not discussed compensation or who was responsible. UCB's concern is, did you use the right material? And these guys repaired a belt that had caught fire. So in repairing that belt, you will actually assume, I mean, if you were UCB, you would normally assume that in repairing the belt, these guys would have looked at, was it a problem that the what was the problem that caused the fire, and do we think that this new belt we are putting in would also suffer the same problem? It's only after that that they would replace the belt. So they would have done so with attention paid to the possible cause of the fire, and therefore 3 is the answer to that question. All right, let's move on to the next question then. Now the next question is about Forbo's letter of 2004. Now what did Forbo state in the letter of 2004? They said it's very unlikely that the fire on the belt was caused by the bread. So now when you say it is very unlikely, what would that normally indicate? I would say something is likely or something is unlikely because I know about the conditions that is going to function in. If you tell me, will this pen write? Then I would say, if you're writing on plain paper, it's very likely that it will write. But if you're writing on glossy paper, it's not very likely that it will write. That means I know the paper you're using. So when you say very unlikely, it means that this person has some idea of the process and is actually of the belief that this is not going to be harmed in that process, isn't it? So in other words, the person was saying, I don't think you're going to have a problem, just go ahead. So I know that the very unlikely would normally indicate two things. One, that they had an idea of the process, and two, that they really believe that there's not going to be a problem. So I need a choice that tells me that they had an idea of the process and that they didn't think there was going to be a problem. So a choice here that says they had no idea, I don't need to look at. Correct? Because we just understood that very unlikely would mean that they know the conditions under which it's going to be used. So I don't need to look at choices 1 and 3 because both of them say they had sorry, not 1 and 3, what are we saying? Only one. Choice 1 tells us they had no idea of the nature, but we know that very unlikely would mean that they did have some idea. So I go down to 2, 3 and 4. But the other part of very unlikely is we know that they were saying, don't worry, you're not going to have too much of a problem, which means they're telling them, go ahead and use it, which means they were offering reassurance. Now 2 tells us, but they were offering no reassurance, right? So that's wrong. And 3 tells us they're offering confirmation that their material would be affected, which is again no reassurance. So that is wrong. 4 tells us that not only had they an idea, you would normally assume that they have an idea of the nature of the naan making process and they are offering reassurance that the material. So while they had an idea, but they offered reassurance that the material would not be affected by that process. So this then is your answer because it carries both elements of very unlikely. That means very unlikely is we know what it is you're going to use it for, but we don't think what you're using it for is actually going to cause any problem to the belts that we're using. And therefore, 4 is the answer to this question. Let's look at the next one. Now the next one says, UCB in taking Spooner and Forbo to court were claiming redressal for what? They were saying that you had failed to take reasonable care in advising us that the conveyor belt was suitable when you wrote your letter saying it was very unlikely. And they're also saying if you had known it was not suitable, then you needed to have taken care to advise us that it was not suitable. So that means they're saying you did not take reasonable care in doing what you did. Basically, this is what answers that question over here, right? This part. What they're pointing out is in either aspect, if you're saying it was suitable, then you should have taken reasonable care to tell us it's suitable, which is what you were trying to imply when you said very unlikely. On the other hand, if you thought it was not suitable, then you should have told us so, right? So I need to understand that this is a lack of care. So were they claiming Were they claiming a remedy or redressal for trespass, which is where somebody is on somebody else's property? No, that's not the case here. Were they claiming remedy for negligence? Negligence as in you should have taken reasonable care but you didn't. That's exactly what the paragraph here talks about. So this is relevant, right? Or were they claiming remedy for misfeasance? Now misfeasance is that you don't carry out an act properly. Over here, you might look at that and say, yeah, they didn't carry out their act properly. No, but what was it that caused the fault? What it was that caused the fault was that they did not take adequate care in carrying out their act. So that means while you might look at 3, negligence is clearly what caused that improper act, isn't it? So the act of repair was not carried out properly because they were negligent. That's your primary statement there. So you're looking more at negligence and you're looking at misfeasance. And it's certainly about not about nuisance, because nuisance is where your act or your condition actually causes harm or offense to other people, and that's not the case over here. It was not a condition that caused the harm, it was the improper use of belt, and that was because of negligence on the part of Spooner and Forbo. So 2 then is the answer to this question. Let's move on to the next one. So the next one tells you or asks you, Lord Hodge, the judge, highlighted 3 common characteristics that should be considered when determining whether it is fair and just and reasonable to impose a duty of care. That means when a person makes a statement, if you're going to say that they should have been careful in making that statement, then to determine whether you can claim that they should be reasonable, there are 3 characteristics that he wants you to keep in mind. Now you realize those 3 characteristics are here in this paragraph. He actually talks about them here. And he says that the 3 characteristics are, you must consider whether what the context of the statements are. You should consider whether somebody is going to rely on those statements when they are made. And you should consider whether the statement contains qualifications, as in it is good for this but not good for that, or so on and so forth. So what you want here are certain aspects of that case are that correspond to these characteristics are as follows. And therefore what they want you to do down at the bottom is pick the choice that presents these characteristics in the sequence that corresponds to the judge's sequence. So we are keeping the judge's sequence as a standard, and we are going to match these characteristics to the judge's sequence. Now let's see. What are the characteristics given to us? Whether Forbo's letter was calculated to give reassurance. And if it was calculated to give reassurance, then you are looking at the business of, say, are people going to rely on my statement, right? So that means 1 here corresponds to the judge's 2. So 1 here corresponds to the judge's 2, right? So you have that. Now, the second statement is whether the correct material had been used in the replacement belting suitable for intended use. That is what the entire case is about. Whether correct material had been used is the entire case, right? And therefore, that is the context in which the statement is made. So that means 2 here corresponds to 1 in what the judge says. What about 3? Whether the letter from Forbo stated that the belting was suitable for the purpose that UCB had or unsuitable, which is a qualification. And therefore 3 here corresponds to 3 here. The qualifications are talked about in 3. And therefore 3 in these characteristics corresponds to 3 in the judge's list. So that means 2 is my choice for this, because the characteristics here, if rearranged in 2, 1 and 3, would correspond to the 1, 2, 3 of the judge's sequence. So 2 is the answer to this question. Now let's move on. So the next question here. One of the principles presented in the passage is that when statements are made, even if casual, and straight away we know that this is something that the judge talked about, right? Over here, when statements are made, even if casual, the duty of care is, and let's just go back to this bit that we looked at. In particular, he noted that while the maker of a casual statement in a social context may not owe a duty of care, a person making the same statement in a business context may, which means you have to be more careful in a business context when you make casual statements than you need to be in a social context. So basically, I want a choice that says you need to be more careful in a business context than you need to be in a social context. So even if casual, the duty of care is more applicable in a business context. Oh, I want that. So it can't be 1. More applicable in a business context. So it could be 2 than in a social context. as applicable in this as in that would mean that they're equally. No, he's actually saying it's more. No less applicable in social context than business, which means it could be as applicable. In fact, social could be more. So that means 3 and 4 are wrong. What we really want here is 2. So the answer to this question is 2. All right. Let's move to the next one. Now, in his ruling in the last para, Lord Hodge pointed to the defendants doing what? Misrepresentation or negligence or misfeasance or nuisance. Now, you realize when we talked about this, we said that UCB in their claim were talking about negligence. They were talking about the fact that people didn't take reasonable care. But the judge in his, while the judge might have dealt with that, what we are talking about over here, what the passage tells us, is the judge pointed out that these guys were actually giving them an impression that the belt was fit for use. Even though they were aware of their concern, they did say that it was fit for use, which means they said it was fit for use when it was not. Now, that is a little more than negligence. It's actually misrepresentation. So, while negligence over here in choice 2 is what it is that UCB was claiming, what the judge is talking about is the fact that they misrepresented the quality of their belt. They said their belt, or they gave people the impression that their belt was fit when actually it was not fit. So while we are drawn to negligence because the paragraph discusses it as UCB's claim over here, what we want is what did the judge point at, and the judge pointed at misrepresentation. So 1 is the answer to this question. Is it misfeasance? No, he's not talking about how the act was carried out. Is it nuisance? No, he's not talking about the harmful or offensive nature of the act. He's talking about the fact that they gave an impression that was wrong. They gave an impression that was wrong, and when they themselves were not certain about the belt itself. So that means they gave people the impression that the belt is actually okay when the belt was not okay. So that amounts to misrepresentation. And the answer to that question therefore is 1. Let's move on to the last question in this passage. Now, Fobo, in defending themselves, in spite of their use of very unlikely, were claiming what? And we know that that is over here. So we say that Fobo and Spooner, in countering the claim, stated that the expression that it was very unlikely that naan from the ovens would melt the belting was made without any special knowledge. So they were claiming, they were claiming that they didn't have special knowledge. They highlighted that the letter from Fobo did not state that the belting was suitable. So they are claiming that they didn't intend giving the impression of suitability, or they didn't intend to reassure. So I need a choice that says here that they were claiming that they hadn't a complete idea of the nature, and they were claiming that they did not offer any reassurance. So 1 tells me they hadn't a complete idea, but it tells me that they were reassuring. No, I want one that tells me they hadn't a complete idea and they were not reassuring. 2 tells me they had a complete idea, so I don't need to look at that. 3 tells me they hadn't a complete idea and were offering no reassurance. That means they were not reassuring, which is what we discussed. So this then is what we're looking at when we say that very unlikely would mean that they did not, they meant that they did not have any special knowledge, which is the part over here, right? And they did not intend to say it was suitable, which is the part over here, which means 3 then fits the answer that we want. 3 is the answer to what we want. 4 says they had a complete idea of the nature. No, they were not claiming that they had a complete idea. They were claiming, right, that they hadn't a complete idea and that they were offering no reassurance. So 3 then is the answer to this question. And with that, this passage is done and we now move on to the next. So what's our next passage about? We'll read it with some care, the same way that we did the last one. Certain reports last year revealed the traumatic experiences, and trauma would mean hurt, physical or mental hurt. So revealed the traumatic experiences of Indian patients who had received faulty hip implants manufactured by a pharma major. Now, if you know what a hip implant is, then there's no issue here. You know exactly what we're talking about. If you didn't know what it is, you can probably still handle the passage, except it will be a little slow, because you're all the while worrying about what the hell is a hip implant. So we do know that hip implants are synthetic. That is basically they're either steel or titanium joints between bone and hip that people put into that the doctors put into people's hips when their original, let's say their own joints are faulty, as in they are eroded or they're fractured or they're arthritic, so they have hip implants. A more recent investigation, so obviously we know that Indian patients had difficulty with these hip implants. A more recent investigation revealed that the manufacturer had paid hefty compensations to US patients who had received these implants. So obviously the patients in the US also had problems and got compensations from this manufacturer. In India, however seems to indicate that what happened here was contrary to what happened there. In India, however, the same manufacturer challenged orders to compensate 4,700 patients who had undergone hip replacement surgery. So why is he saying however? Because he's saying they paid them there, but they're challenging the order to pay people here. So it would seem as if the person says they paid their own, but they're not paying ours in some sense. The story is not just that of manufacturers' fault. It is also one of regulatory deficit in the country. What exactly is regulation? Regulation is where something is controlled by the government. So you have guidelines, you have administrative, let's say, regulations laid down, and so on and so forth. What exactly does deficit mean? Deficit means a shortcoming. That means less than you need to have, which means this person is implying that a certain amount of regulation is necessary and we have less than we need to have. The investigations pertain to implants that had been manufactured under two brand names. The first was recalled globally in 2010 and the second in 2013. But recalling a medical device is a limited solution. Recalling a medical device is a limited solution. Why is he saying limited? Because obviously he means that it handles only some part of your problem and not all of your problem, right? Defective implants can cause crippling pain, even death. Patients who receive such implants need regular monitoring. They need regular monitoring. Okay? In several countries, track is kept of such patients. In fact, this manufacturer recalled these products more due to official warnings in Australia and a flurry of lawsuits in the US that drew official attention to the device's defects, which means it drew the attention of the authorities and therefore they recalled the products. Fine. In India, in contrast, things moved slowly. Now you realize when you're saying in contrast here, we're saying in contrast to what happened in Australia and the US, here things moved slowly. All right. The first product was caution listed a few months after it was withdrawn. A few months after it was withdrawn. Caution listed would mean be careful not to use this. After and a few months after it was withdrawn from the global market. So that's a slow response. But it took a year for the government to ban its import, even slower. It took them 1 year to say don't even import it, and another, meaning one more year, before orthopedic surgeons were officially advised not to implant it. So the slowness of the Indian administrative response is clear here. First of all, it took them some time to caution list it. It took them a whole year to ban its import, and it took them another year to tell surgeons that they shouldn't be using it at all. These delays are significant because the manufacturer has told a Union Ministry expert committee that it cannot trace as many as 3,600 patients who underwent surgeries involving the 40 implant, which means after all this time of 2.5 years, we can't trace these guys. So that's why the person is saying these delays are significant. Because if there hadn't been so much delay, chances are you could have put your fingers on the people who actually underwent surgeries, but now they can't. That India did not have a joint registry. And therefore, if you are talking about a joint registry, we'll come back to that term, but just keep it in mind. That India did not have a joint registry when these surgeries happened has compounded the problem. Has compounded what problem? The problem of not being able to locate patients. See, over here we have these delays are significant because the manufacturer has not been able to trace, and the absence of a joint registry has compounded the problem. So basically it's about being able to keep track of patients, and we aren't able to keep track because one, there's too much delay, and two, we don't have a joint registry. We'll discuss joint registry a little later. This has also come in the way of ascertaining the damage by the second product, with the manufacturer claiming that it has no adverse reports on that device in the country. That means they're saying nobody has made a complaint to us, so there is no problem. However, reports in the newspapers have highlighted the trauma of at least 7 patients. Now, that means the company might not have reports, but newspapers clearly know that there are certain people who have a problem with that product as well. Now let's get back to joint registry. What's a registry? Registry is where you register people. That means where it is that you keep note of people or where it is you list down the operation that you carried out. Now that would be a registry that the hospital maintains. What's a joint registry? That somebody else also then is part of that. So who else would be? Either the company also, that means the company and the hospital are interested in who gets the implant, or government or the regulatory authority. So the authority and the hospital, maybe the authority and the hospital and the company, whatever. But joint registry means more than one person was actually keeping track of these patients. And if they had kept track of these patients, and that means the hospital and the regulatory authorities, then identifying these patients would have been much, much easier. So, while the government has now issued the medical devices rules, the country's base legislation on implants continues to be the Drugs and Cosmetics Act of 1940, which does not have the scope to cover modern healthcare devices. That means that act is not good enough to cover devices. With the huge Indian market currently valued at over $450 million and expected to grow by 30% per year, the investigations into faulty hip implants bring out the urgent need for a law to regulate medical devices. So, urgent need for a law to regulate not only hip implants but any other medical devices as well, which means all medical devices have the same suffer the same regulatory deficit, which means there isn't joint registry, there isn't proper follow-up or tracking of people, not able to get hold of people who had the surgeries, etc., and so on. So we've understood this. Not a very complex passage. Now you realize if you did know what a hip implant was, then the significance of what you're talking about here becomes pretty clear. If you didn't know, then you actually have to pay a little attention the way we did to figure out what it is that you're talking about. That means, okay, I don't know what exactly it is, but obviously it's a device that needs to be kept track of because people could have a problem with it. Fair enough. Now let's look at the questions that we have here. The first question says, in telling us the manufacturer had paid hefty compensation to US patients who had received these implants, however, the same manufacturer challenged the orders to compensate. The however seems to tell us that there is a contradictory situation here. In one case you paid and in the other case you're challenging. And it would seem then that what you did there you're not doing here. So in saying this, the author seems to imply that the manufacturer is adopting double standards, one standard for the US, another standard for India. Which of the following, if true, would show that this may not be the case? Which of the following if true? Which means this is a reasoning question. So you have to ask yourself, if you're saying there are double standards, well, double standards can only be double when you are addressing the same circumstances. That means in the same circumstances, you treat A differently and B differently, then you have double standards. But if A is treated under one separate set of circumstances and B under a different one, then you really can't talk about double standards. So if you want to identify a statement that says it may not be a case of double standards, then you have to say that they both don't look at the same thing. That means the payment there cannot be compared to the challenge here. In other words, you compare payment with payment or you compare challenge with challenge, but you can't compare payment and challenge because when the payment happened, you don't know if it happened with the challenge or without. So in other words, if it happened without a challenge, then the challenge here would be double standards. But if it happened after a challenge, that means the first step of their process was actually a challenge, then over here they are undertaking the same first step. So if I get a choice that says that the payment there was after challenge, then I know that there are no double standards. Okay, let's look at that then. The US payments were made following a settlement out of court. If they settled out of court, it means they didn't challenge. The patients claimed and the company paid, no challenge at all. In which case, this would show double standards. But we want a choice that does not show double standards. The US payments were made following court orders on a class action upheld by the relevant appellate court, which means that people went to court, their claim was challenged, then there was an appeal and the claim was challenged there also, and then there was an order asking them to pay, which means the US payments were made after a challenge. If they were made after a challenge, then very clearly the same process is being followed here, as in here also they will challenge. What the challenge is going to lead to, we don't know yet. But in the US, they obviously, going by statement 2 here, if we look at statement 2, then we know that in the US, the payments happened after a legal challenge, which means there is no double standards, that we are not looking at a case of double standards. What about 3? The US payments were made to over 10,000 individual claimants. Doesn't matter. What we really want to know is whether they challenged or not. 4. The Indian orders to pay were by the government and not by a court of law. Doesn't matter. Again, They're challenging the Indian orders. We want to know whether they challenge the US ones as well. So the only statement here that holds open the possibility that they did challenge before they paid is in two, because they challenged and even went to court and even went to appeal, right? So two tells us that there's a challenge there, and therefore there aren't any double standards adopted here. Let's look at the next question. Now the next question tells us the manufacturer's fault isn't turning out faulty implants, as we know in para 1, right? So you realize over here we are talking about the manufacturer's fault wasn't turning out faulty implants. Which of the following civil wrongs would it amount to? So if you're saying that they had violated somebody a duty towards somebody, what would that violation be? Does it amount to nuisance? But nuisance is a human activity or a condition that is harmful or offensive to others. A human activity or a physical condition that is harmful. No, but here we are talking about an implant. We're not talking about an activity that was engaged in. Was it misfeasance, an act that is legal but improperly performed? What act did they perform? The act performed was an operation, but over here the claim is not against the people who carried out the operation, it's against the people who made the implant itself. So it's more about the device. Is it negligence, failure to exercise the appropriate and ethical care expected to be exercised under specific circumstances? Now, we are talking here about an implant. Now, we did discuss that an implant is something that actually goes into somebody's body and is going to be fixed there permanently. Now, if something is going to go into somebody's body, then there has to be a great amount of care put into its manufacture, because if it's not properly designed, if it is somewhat not properly finished, if the materials used are not suitable, then it will actually harm the person. So anything that's going to be put into the body requires to be dealt with very, very carefully. That means not only in its manufacturing surgery, but also in its manufacture. So the manufacture needed to have been with great, great care to ensure that there was no fault. So if it was faulty, it would mean that the manufacturer had been negligent. They didn't exercise the appropriate care that they should have. So that means 3 is what we are looking at. 4, misrepresentation. But to say misrepresentation, we have to consider what they told people, what kind of brochures they had, what kind of publicity input did they provide. We are not told all that. So we can't actually talk about misrepresentation here. So very clearly the answer here is negligence. Okay. Let's look at the next question. The next question says, which of the following is the most likely reason that the author says that recalling a medical device is a limited solution? Recalling is a limited solution. Now let's just look at that. What exactly does recalling mean? When you send out, when the manufacturer tells stockists or distributors or whoever it is who's keeping their product for distribution into the market, and they tell them, don't distribute this into the market, we need to call it back. That is recall. But when you recall a medical device, yes, you are in some sense ensuring that you've got the faulty devices back. But whom does it help? It only means that these devices are not available for further use. It only means that the devices are not available for further use. It does not help those who already have the device. So I know it's a limited solution because it only it only ensures that there will not be a problem with these hereafter. What about the problems we've already had? So this doesn't deal with that. That's why he says recalling a medical device is a limited solution, because it only ensures that we won't have any more problem. The problems we've already had, we've had. So substantial damage is already done is not an answer to you're saying damage is done. We are saying, why is it a limited solution? What is limited about the solution? What's limited about the solution is that only subsequent damage is stopped, which means the only statement I have there is 4. 2 tells me prospective damage is inconsequential, which means prospective damage is so small it doesn't matter. In that case, it doesn't need a solution. Earlier damage is all that matters. Again, in that case, the later damage or possible damage doesn't need a solution. Only prospective damage is averted, would mean only forthcoming damage, only possible future damage is averted. That's what prospective means. What is likely to happen, isn't it? So our answer here would be 4. All right. Let's look at the next question then. Now, the use of the words regulatory deficit in para 1 would imply that there is an appropriate level of regulation. If such regulation were not justifiable, it would amount to a violation of which of the following? So the use of the words regulatory deficit imply that there is regulation needed. That's why you're saying deficit. So if the regulation is needed, in what is that regulation needed, right? We recognize that the regulation wasn't keeping track of people. Now, if that regulation were not justifiable, it would amount to a violation of which of the following? What would be violated? Well, what would be violated would be that you're going to stop people from doing their business freely as far as this product is concerned. So it's about people being able to carry out their business. Is that related to protection of life and personal liberty? No, it's not. Is that related to protection in respect of conviction for offences? No, it's not. Is that related to the right to equality? No, we are not talking about discriminating between suppliers. Is it the right to engage in any occupation, trade, or business? Yes, because if the regulation was not justifiable, it would mean that for reasons which are not, let's say for reasons which are not worthy, or for reasons which you shouldn't have, you're actually stopping people or you're trying to control their business. So it would actually, in some sense, interfere with the rights to engage in any occupation or trade or business, right? So that would be 4. Then what else are we looking at? Regulatory deficit says this question. The use of the words regulatory deficit in para 1 would imply that there is an appropriate level of regulation. From the rest of the passage, we can understand that such regulation is in what? And we know over here, if you're going to consider what we have here when we talk about the business of so patients who receive such implants need regular monitoring. All right, they need regular monitoring. In several countries, track is kept of such patients. In India, in contrast, things move slowly, etc., etc. Now, these delays are significant because the manufacturer has told the Union Ministry that it cannot trace as many as 3,600 patients, which means tracing them, if you had regulation that would help you trace them, that would be required. That India did not have a joint registry when these surgeries has happened has compounded the problem. So the point here is this guy is saying that we haven't kept track of people who actually underwent these operations, who got these implants, to be able to determine whether their implants were okay, whether they had a problem with it, whether the product should be allowed or not. In other words, we did not have a feedback system. So where the regulation is short or where the regulation has fallen short is in not ensuring that there is a feedback system. So the regulation is therefore not about the quality standards and systems maintained in the manufacture of implants. That is statement 1. That's not the case. It's not about the standards whereby patients are prescribed the implants. That means how do the doctors tell them that they have to get it. But it is in the standards and systems whereby feedback is regularly gathered on and from the recipients of implants so that you can keep track of how they're doing and what's happening with the implants. So 3 then is the answer to this question. 4 says standards and systems whereby surgeons carry out hip implant surgery. This is not about telling surgeons how they should carry out their surgery, right? So this question then is the one that remains in this passage. So with this, we finished this passage. Now let's move on to the next passage that we have to deal with. Okay. The next passage is one on a ice hockey game and something that happened in it. Let's read the passage first. In a 2020 case, a plaintiff was awarded $700,000 in damages against a defendant who delivered a blindside hit during an ice hockey game. What is a blindside hit? I think even if you break the word up, you'll learn blindside. That means hitting someone from their blind side, on their blind side. In other words, approaching and hitting somebody from a side that they could not see. If I can't see a person approach, if you're coming to me at an angle, from an angle which I cannot see you, where I can't see you, then that's a blindside hit. Okay. In a game in 2012, the plaintiff had passed the puck into the opposite corner while rounding his own net in a routine counter-attack. Meanwhile, the defendant was taking a run in the same direction across the goal mouth, skating at top speed. And you know, people skating at top speed on ice are skating really, really fast. The two collided just past the goal line to the side of the net as the plaintiff had started to turn past the net. And there you get the blind side. This guy started to turn, he didn't see this chap coming, and then he was hit. Reconciling the different versions of events recounted by various witnesses at the trial, the judge established that the plaintiff head down was not expecting the hit, while the defendant arms up fully anticipated the collision. How did the judge establish this? He listened to different people. But these different people had differing versions. But when you say reconciling, you're saying in those differing versions, the judge was able to establish common factors. While people might have had different versions, in those different versions were certain commonalities that helped the judge determine that the plaintiff did not expect the hit while the defendant did. Upon impact, the plaintiff lost consciousness, lying bloody and motionless on the ice. He had suffered broken front teeth, multiple gashes on his face and inside his mouth, and concussion. The defendant was penalized by the referee for gross misconduct and for an intent to injure. This is the referee. He was later criminally charged. Now, this goes to the police. He was later criminally charged and convicted. He was convicted as well. That means he was taken, the charge was taken forward and he was convicted of aggravated assault for the hit. Aggravated assault would mean deliberate and violent assault. But on appeal, a new trial was ordered because obviously on appeal they believed that that judgment was not actually quite okay. At the retrial, the defendant was convicted for a second time. He was convicted for a second time, but then he appealed again. On appeal, again, the conviction was quashed, which means that the first trial was quashed for some reason, and the second trial was quashed again for a different reason. The conviction was quashed, and this time the charges are also stayed on grounds of unreasonable delay in bringing the trial, which means apart from saying that there is no criminal conviction, they also said now you can't appeal this anymore because there was unreasonable delay in the retrial claim. In the civil action, okay, so now we know that apart from the criminal action, there was also a civil action. The issue was whether the hit went beyond the bounds of fair play. Considering the level of play, applicable rules, and the nature of the game, the judge assessed that it did. So the judge believed that it did go beyond the bounds of fair play. The defendant had skated towards the plaintiff at a high rate of speed from an angle where he could not be seen, which is exactly what we are saying when we say blindside, correct? The plaintiff could not expect the hit and hence did not make any attempt to avoid the contact because he didn't know it was coming. In contrast, the defendant had raised his arms and put his shoulder down in order to maximize contact, which means he knew what was going to happen and he put himself in a position where he can actually hit hard and maybe not cause so much damage to himself. The judge thus concluded that the hit was either intentional or reckless. But that means either intentional or reckless would mean that he is not absolutely certain about whether it was intentional, so he could go with reckless. And that the defendant had failed to meet the standard of care applied to applicable to a hockey player in the circumstances. And that would clearly mean reckless, which means without any care at all. Therefore, the defendant was fully liable for the collision and plaintiff's injuries. That means he should have taken care. He didn't take care, therefore he was liable. The judge awarded 100,000 in general damages, 200,000 for past loss of income, and 400,000 for future income loss to reflect the plaintiff's decreased earning potential as a self-employed personal trainer. Okay, so what do we have here? That this guy skating at high speed hit the other guy who did not even expect him. The person who got hit was very, very badly hurt. And there were two cases that came up. One was a criminal case, but the criminal case did not go any further because there was no criminal conviction that the appeal court came up with. And in the civil case, the judge actually identified that the defendant was actually really, really reckless and therefore responsible, and therefore he awarded damages that this person should pay to the person who was hurt. Okay, now let's come down to the questions. Which of the following is best understood from the second paragraph? Now, in the second paragraph, they're telling us they're describing the nature of the accident and they're also saying how the judge established what he established. Now, the choices here don't talk about the description of the accident, but they do talk about the judge and what he arrived at. Now, I know that the judge arrived at a common understanding. He arrived at an understanding of what happened from the common parts of the different versions given to him. How do I know common parts? Because of the word reconcile. What do you mean by reconcile? To see where things meet. So getting to see the meeting points in different versions, he was able to say that the plaintiff didn't expect the hit and the defendant did. So it is possible for a judge to put together common aspects and arrive at some understanding of what happened. So judges cannot arrive at the truth is out. We know that the judge did arrive at the truth looking at common aspects. Even from differing versions submitted in evidence, judges can arrive at the relevant truth by recognizing commonalities, which is the same thing as you're reconciling. So 2 then actually works, right? That we understand. 3. Judges can arrive at the relevant truth, okay, when the various versions submitted in evidence present the same view of events. If they present the same view, there's no need to reconcile, isn't it? There's already, everything is okay, so what is there to reconcile? 4. When presented with differing versions in evidence, judges can arrive at the relevant truth by disregarding the versions that don't correspond. If they disregard ones that don't correspond and take those that correspond to only that truth. First of all, how did they identify the truth? And secondly, where's the question of reconciling? So the key word here in this particular part is the reconciling, and the reconciling tells you that you've got to look at commonalities. And therefore, 2 is the answer to this question. Let's look at the next question. Now the next question is, which of the following can be understood from the content of the passage? And the choices are all about cases that can arise. Can civil case, criminal case, etc., as in all the choices. Which means they are actually talking about the types of cases that came up from this event, isn't it? An event can give rise to either a criminal case or a civil one, but not both. So let's just see. We know that there were criminal cases, right? But we know that the criminal cases were eventually, or the criminal case was eventually quashed. But there was a criminal case. In fact, there was a criminal case. It was upheld once. It was upheld the second time. It was quashed the third time. Right? Then, we also know that there was a civil case right here, isn't it? So, in the civil action, we know that there's a case here. So, the point is, we know that this event gave rise to two cases. One, a criminal case, and one, a civil case. So if you look at choice 1, it says an event can give rise to either this or that, but not both. But we know that over here it gave rise to both. So 1 is not the answer. An event can give rise to a civil case when there is no criminal one, or only when the related criminal one fails. Now we know that the civil case happened even though there was a criminal one, but we are not told anything to say that the civil case followed the criminal one. If you say in the following civil action, then I know, but we are not told that. So we know that they could possibly have been parallel. So I would rule out 2. An event can give rise to either a criminal case or a civil case or both. And over here it does give rise to both, which means 3 works, isn't it? So we are actually saying an event can give rise to both. So 3 works. An event that gives rise to a criminal case cannot give rise to a civil one. No, but that's not the case, because over here the criminal case happened and a civil case happened as well. So 3 is the answer to the question. Let's look at the next one. For an act to be adjudged criminal, it should be a wrongful act, and they call that actus reus. And it should be with wrong intent. They call that mens rea. So actus reus is the wrongful act and mens rea is wrongful intent. Now, did we have a wrongful act here? Yes, we did. Did we have wrongful intent? We don't know. We don't know whether the person intended to establish, or because you realize the judge finally said it was either intentional or reckless. So if it was reckless, then intention is not what we're talking about. We're just talking about a lack of absolute care. So in the context of this passage, which of the following is the most likely to be the reason that the criminal case was quashed? That means, why was the criminal case thrown out? Now the criminal case was thrown out because obviously there wasn't enough to make it criminal. What do you need to make it criminal? It needs a wrongful act and it needs wrongful intent. Did we have a wrongful act? Yes. Do we have wrongful intent? Can't say. So it was not possible to establish actus reus or wrongful act? No, we could establish that. We know what exactly the accident was and how it happened. It was not possible to establish mens rea. That's right. That's why the judge says either intentional or reckless, because he didn't have enough evidence to establish exactly that. So it was not possible to establish mens rea. So 2 then becomes the answer to this question. What about 3? It was possible to establish neither actus reus nor mens rea? No, but actus reus we were able to establish. It was not possible to establish that mens rea was corresponding to the actus reus, which means we've got an act, we've got intention, but the intention is not related to the act. Over here we realized we weren't able to determine intention. So the mens rea does not apply. So 2 is the answer to this question. Let's look at the next one. One of the principles of tort, civil wrongs, is that normally one cannot claim injury when one has consented to the possibility of such an injury. Voluntary non-fit injuria is the Latin term. So if the person had voluntarily implied that he is actually going to accept the risk, then he cannot claim injury. So why is it that this principle has not been applied in this case? Why are we not saying that the player, when he got onto the field, was actually going to accept the risk of anything that happens to him in his game? The fact is, players do accept risk. The fact is, when a person gets into a game, they realize that there is a possibility that they might get hurt. But the point is, there is a possibility they might get hurt is something that they accept as long as the actions are within the rules of the game. Now, if playing within the rules of the game, so for instance, in cricket, if somebody hits the ball really, really hard and it goes and glances a blow off somebody's helmet, like bowlers sometimes bowl really hard and a blow is glanced off a batsman's helmet. The fact is that they are taking those risks because they know that this is something that's likely to happen. The person is playing within the rules. But do they really accept things where people are not going by the rules? So, for instance, if the bowler actually picks up the ball in anger and flings it at the batsman's face, is that within the rules? No, it's not. So, is he accepting that kind of risk? No, he's not. So, the point is, people in sports do accept risk, the kind of risk that comes out from the game played by the rules. Just because the person is playing the game doesn't mean he's accepting any possible risk, even if it came out from really, really bad behavior. So, let's look at the choices. Why was the principle not applied? Very obviously, it was not applied because they couldn't say that the person consented to that injury. Why are we saying that? We can only say it if the injury happened beyond the rules of the game. So, while players implicitly consent to the risk of injury in fast paced and violent sports, that consent is not unlimited, meaning there is a limit to that consent. That is true. That consent is not unlimited actually does make sense. So, I could look at this as an answer. But then you realize we looked at this earlier. You don't go with the first answer you get. Please look at the rest and say there is no other answer there, so this is the answer. So if I don't have another answer, then I'll come back to one. But if I have another answer which is a little more detailed, then that would be my answer. 2 says, while players implicitly consent to the risk of injury in fast-paced and violent sports, that consent is unlimited. No, that consent is not unlimited. It is limited, as we discussed, to only those kind of injuries that happen in the course of regular play. So it's unlimited even when the conduct is out of the ordinary or beyond the rules of fair play. No, very definitely not that. What about 3? While players implicitly consent to the risk of injury in fast paced and violent sport, that consent is not limited to conduct that is out of the ordinary. If it's not limited to conduct out of the ordinary, you're saying that even conduct out of the ordinary is within the boundary and it goes beyond that. No, we are not talking about that. 4. While players implicitly consent to the risk of injury in fast paced and violent sports, that consent cannot be assumed when conduct is out of the ordinary. That means the person, you can't say that the person has consent when you're talking about actions which were beyond the bounds of fair play, beyond the rules, beyond the applicable rules and nature of the game. And that's exactly what happened over here. The fellow was hurt or he was injured because the other guy actually engaged in play that was a foul. And people are not consenting to the hurt that happens because of gross violation of the rules. Which means while one works, 4 works much better because it gives you the detail. It says that you cannot be assumed that a person is consenting when the conduct is beyond the bounds of fair play, beyond the applicable rules, etc. Which is why 4 is the answer to our question over here. Okay, so that's your answer. The next question is, what would be the appropriate category of damages award in this case? Now let's look at the damages here. The damages are down here. What did the guy get? He got 100,000 in general damages. What are general damages? Well, damages for the costs of the suit, damages for the medical treatment that was involved, damages for the transportation on and off the field to the hospital, all of that. So the judge awarded $100,000 in general damages, obviously the cost that the person had incurred. 200,000 for past loss of income to compensate the person for whatever income he had lost while he was hurt and in hospital, and 400,000 for future income loss to reflect his decreased earning potential as a self-employed personal trainer, which means this guy was employed as a trainer but now will not be able to pursue that employment, and as a result his future income is probably going to be less by about $400,000, which means what the judge is looking at is to compensate him for what he has already incurred, right? Then to compensate him for what he has already lost and to compensate him for what he is likely to use in the future. So all of it is compensatory, right? So all the damages here are compensatory, which means that 1 is the answer to that question. Are the damages punitive? Now, punitive damages would mean damages which are heavy with for the sole purpose of delivering a lesson. We are not told from the conversation or from the discussion here that the judge really wanted to teach the person a lesson. That is not the case. So we are not looking at punitive. Restitutionary would mean you award a person damages, taking away whatever gains the other person got. But over here, we are not saying that by his wrongdoing, the defendant actually gained anything. He didn't gain anything that needs to be returned to the defendant. And therefore, we are not looking at restitutionary damages either. So compensatory damages are what we are looking at. So that answers this question. Your choice would be number one. With that, we are done with this particular let's say set of questions that we had. We had three passages here and we had questions that followed those passages. Now let's also look at something that helps over here. We did say that keeping in mind principles that we've gone through, we would be able to, or some where we have some basic idea of principles, we would be able to recognize those principles in this particular discard, in this particular set of passages. We would also be able to relate the principles to those situations if we thought about it. But you also realize that in addition to all of that, there is something else that helps. One, of course, careful reading helps, that's obvious. And then careful use of your language or recognizing how language is used, that also helps. But more than that, a little bit of general awareness helps, isn't it? Now, for instance, if you take the second case, the one about hip implants, if I didn't know what a hip implant is, then I'm going to be a little slower at reading and understanding that passage than somebody who does know. Similarly, let's take the ice hockey one. If I knew how an ice hockey game is played, if I knew what the format is, if I had some sense or I've at least watched it on TV once in a while and know what kind of actions happen there, then I'm much faster at picking up the content of that passage than somebody who hasn't that idea. So the point here is that additional reading and a slightly wide reading habit in terms of things that happen to you that appear in the newspapers, magazines, on the internet, etc., gives you a certain general awareness, and that helps a great deal in picking up situations so that you're faster than other people. Sometimes, I'm not saying it's possible to come across every situation in the world, but if you have come across some sport, some game, some scientific development, let's say, and those are discussed as part of these passages, then you handle it much faster than those who haven't had that exposure. So what you need then is also a wider reading habit apart from your basic legal fundamentals training. All right. So do some reading, do some practice, get together all these things in terms of being able to identify principles and apply them to situations, and you should be able to handle legal reasoning without a problem at all. It's a really exciting area because it helps you understand how to apply the principles that you learn. It helps you understand how to assess situations that you deal with. It helps you understand how people present their arguments and counter those arguments. And it helps you understand how common sense and fairness actually helps you deal with these things. So legal reasoning is an exciting area. It's no surprise then that it's part of the exam. But you realize when things are part of the exam, we tend to consider they're not exciting. So don't look at it only from the point of the exam. Look at it as a challenge to your thought processes and you will really enjoy it. Take care. All the best.